Next slide, please. Thank you. Perfect. So now the Holy Quran gives a Muslim and tells Muslims what the command of God is and what the injunctions are for a Muslim to live a life according to the Sharia. And the commands and injunctions in respect of establishing prayer 5 times a day, going on the obligatory pilgrimage, giving in charity, and fasting during the month of Ramadan. All of these are included within the Holy Quran. And Muslims believe that this was revealed to the Prophet Muhammad through Gabriel, and it's the direct word of God. I could talk for a long time about this and how the method of revelation occurred and the authenticity of the Quran. But when I did a dry run of this with Mrs. Patel, she said, if you carry on talking anymore, you're going to overrun. So I'll say very quickly, just one example to understand the importance of the Quran, but also how it works in tandem with the Hadith, which is point number 2, which is the sayings of the Prophet Muhammad. Now, the Quran tells Muslims that they must establish prayer, but nowhere in the Quran does it actually say how to establish prayer. And if you've seen Muslims praying, you'll know that there is a certain form and methodology on how a Muslim prays 5 times a day. Now, the mode and methodology as to how to establish prayer, that's contained in the sayings and the practice of the Prophet Muhammad, and these are known as the Hadith. Now, again, the science of Hadith, and I say science because it is an actual science which students of Islamic theology who go on to become jurists and scholars actually study for a number of years. It is very complex and very interesting, but suffice to say, I think what's good to know, what's important to know, is that there are different classifications of Hadith. So you can have strong Hadith and you can have weak Hadith. And by that, a strong Hadith is a saying or a practice of the Prophet Muhammad, which has been seen and recorded and transmitted from the time of Prophet Muhammad to this day, or to the text which records it, to a chain of narrators. And also that each narrator in that chain has been verified as somebody who is a reliable narrator. Now, within the Muslim world, after the Quran, the most authentic book regarded in the Muslim world is something called Sahih al-Bukhari. Sahih al-Bukhari is a collection of about 7,200 sayings and hadith of the Prophet Muhammad, compiled by the great jurist and scholar Sheikh Bukhari. And it's these hadith which are known within the Muslim world as entirely and absolutely strong hadith when it comes to, which are in this book, sorry, and there are no weak hadith in that book. Now, the general thing to understand is this: that if it's a hadith or saying or action of the Prophet Muhammad which relates directly to an obligatory act of a Muslim, then it must be a strong hadith. If it's not a strong hadith, it's not regarded, and it's classified as a weak hadith. But if it's an action which relates to enjoining Muslims to do, for example, good deeds, for example, like how many times people should pray the word subhanallah, or which chapters of the Quran have more virtue, then in those sorts of situations, slightly weaker hadith are accepted because they don't pertain to obligatory commandments. The third type of source of Islamic law is ijma, which is the consensus of Islamic scholars. And that is to say, the consensus of a worldwide body of Islamic jurists and scholars on matters which relate to either the Quran or the prophetic traditions, so the practice of the Prophet Muhammad. And now, when that occurs, when a group of scholars unanimously agree on something, it's called ijtihad. And during the reign of the Muslim Empire, there was lots of ijtihad because Islamic learning was everywhere within the world, and it was during the golden period of Islam, and there was lots of debate and lots of scholarly debate around this. Recently, ijtihad, or nowadays ijtihad, is extremely rare for that to happen. And finally, qiyas, which is the jurisprudence derived from legal analogy. And this is something that I'll be referring to a lot when I talk about what the position of Islam is and what the position of the Sharia is when it comes to, for example, financial provision for women and children, or whether fathers should be allowed to have contact. Because you'll see by the end of this presentation that there are certain Islamic principles. But what I always argue and have argued, and what I've always derived from my conversations with scholars and jurists, is that this is very much an area in which qiyas is applied. Now, there are 4 schools of thought within Islam. The 4 main schools of thought are Hanafi, Maliki, Shafi, and Hanbali. And they are each named after the jurist who founded them. And they are highly regarded in Islamic circles as jurists and scholars of the highest scholarship. Each madhab, each school of thought has its own criteria for the interpretation of these hadith that we discussed, of hadith of Prophet Muhammad, and also of interpretation of verses of the Quran, which is why there's sometimes discrepancy and what we call ikhtilaf, or difference of opinion between jurists. Now, as Muslims, we believe and we understand and we know that these 4 schools of thought are essentially a codification of the laws of Islam as per that particular jurist, and all 4 are accepted as correct. And it's not to say that one school of thought is correct and one school of thought is incorrect. I myself follow the Hanafi school of thought. The Hanafi school of thought will be the basis upon most of the comments that I make today. But that's not to say that I disregard or disagree with the Maliki, Shafi, or Hanbali school of thought. I think, if my memory serves me correctly, about 1/3 of the world's Muslims follow the Hanafi school of thought. But it depends on which region, which part of the world you're in. In the Middle East, it's usually the Hanbali or the Shafi school of thought. In Africa, it's more the Maliki and the Shafi school of thought. In the South Asian continent, it's usually the Hanafi school of thought. Moving on to the definition of marriage in Islam. So marriage is what we call a sunnah, a practice of all the prophets that Muslims believe came into the world, peace be upon them. The Arabic word for marriage is nikah, and it literally means union of marriage between a husband and between a man and a woman. Now, down at the bottom of the slide, I've put one of my favorite verses regarding nikah. Please excuse the vibrant blue font of the verse, but it reads "Hunna libasul lakum wa antum libasul lahunna," and it's a translation of the verse of the Quran where God is saying that they are a clothing for you and you are a clothing for them, and that is in reference to the relationship of husband and wife. And I like this verse because when you read the tafsir, the explanation of different verses of the Quran, when you read what's been written about this verse, it's amazing. Because what is the purpose of a piece of clothing? It covers our bodies. It provides us with adornment. It's actually the closest thing to our bodies, to our skin, and it hides any blemishes, any faults, any marks. And using that analogy, God is saying that the relationship between husband and wife is similar. That a husband and wife protect each other, they hide each other's faults, they are very close to each other like a piece of clothing in, and also they adorn and beautify each other's characteristics. So I thought I'd put that in there because it is a verse which always reminds me of the beauty and the spirit of nikah and the spirit of any relationship, to be honest. Now, moving on to the Islamic methods of separation for a married couple. Next slide. There are a number of different ways. Death of one of the parties, granting of the divorce by the husband, that's known as talaq. That's where the husband unilaterally grants the dissolution. Separation by way of consent between the parties as requested by the wife, that's khula, and that's upon returning of either part or some of the meher. Nullification and the dissolution of the marriage, fasq and tafriq, we'll cover that when it comes to other methods of separation which don't involve the husband and wife and when a third party is involved. And in my experience and in this day and age, nullification and dissolution are interchangeable terms, especially in practice as to how it happens in the UK when a Sharia council is involved. And finally, delegation of power to grant the talaq given by the husband to the wife. Now that's something called tafweed al-talaq, and essentially means that the husband gives his right to divorce to the wife as well, so that she can unilaterally divorce herself if she wants. And I've got a separate slide on that. We'll talk about that in a bit of detail. Next slide, please, Helen. Thank you. So I thought at this point it'd be good to touch upon what khula is. Now, because you may have had clients come to you and say, oh, we've had our khula, or he's not granting me my khula, or words to that effect. They probably don't mean a khula. Khula is, in my opinion, the closest thing to consensual divorce, where the wife wants a divorce, husband doesn't really want to give it, but upon the request of the wife and agreement that she pays back either some of the meher or all of the meher, which is the dowry, then he grants her the divorce. And the khula is classed as a proper irrevocable divorce, talaq-e ba'in, and I'll explain what talaq-e ba'in is further down the line. Now, a few points to understand here. If there is no return of any item, then it's not a khula, and it can just be a talaq. But the wife can return some of the meher, all of the meher, or as in some discussions with some scholars, in some cases, even if it's a penny, as long as there is some consideration, then it can be classed as khula. It stems from an incident which happened during the time of the Prophet Muhammad, when one of the wives of his companions approached the Prophet Muhammad and said, and informed the Prophet Muhammad that I have no issue with so-and-so. The companion was called Thabit bin Qais. And she said, I have no issue with him, but I just don't want to stay with him. And the Prophet Muhammad brokered an agreement whereby she returned some of the dowry that had been given to her upon nikah. But most importantly, no allegations were made by one party against another. So that's why I believe it's consensual, no-fault divorce, as it hopefully is coming into play in a few months' time in our jurisdiction. So that's khula. And when most people who come to you as clients will say that they want a khula, or he's not giving me the khula, or do I need to give khula? Now, khula happens when there is consent and when no allegations are being made. When the wife requests a divorce and the husband refuses to give it, then the type of dissolution that they're actually talking about is not called khula, it's called fask or tafriq. And that is, in a Muslim country, the wife would petition the court, the qadi, who is the Islamic judge or the jurist, and petition for a dissolution or nullification of the marriage. And in a non-Muslim country like Britain, we have the existence of Sharia councils, where you have a panel of scholars and they dissolve the marriage based on the grounds of fask and tafriq. Now, fask and tafriq are very similar to the ground of behavior in the Matrimonial and Causes Act, in that it is a subjective test as to what constitutes fask and what constitutes tafriq. Yes, there are some general broad brush points that are laid down in the texts about what constitutes tafriq and fask, but generally speaking, and again, a seminar on Sharia councils is something which, it's a whole different seminar. My experience of working with Sharia councils, my experience as somebody who's advised and sat on a panel of a Sharia council a long time ago, is that the reasons given by a wife to a Sharia council for a marriage to be dissolved on the basis of fask and tafriq are exactly the same, or is the subjective test and exactly the same as those given when filing a petition at court on the ground of behavior. So it's important to distinguish between these two. And most people, 99% of people, will get this wrong. Next slide, please. Moving swiftly on. So the three types of talaq: talaq raji, ba'in, and mughallada. They are so raji is revocable, ba'in is irrevocable, and mughallada, it should actually say severe irrevocable divorce. Please accept my apologies for that. Now, talaq raji, firstly, which is the revocable divorce. And I'll go through each separate type of divorce with a quick mention of procedure and how it comes about. So first of all, for talaq raji, that is when either one or two words of talaq are said by the husband, and those words have to be clear. They have to be sarih, as the Arabic says, which is clear words that indicate talaq. either by saying I give talaq raji or I give one talaq. And in an ideal world, as we know through practice, and it's better if that is recorded in writing. Through practice, you will also no doubt agree with me that these things do not happen, and people simply say that you may have heard of situations when talaq has been given over the phone, for example, or when it's been given in the presence of independent witnesses, or as happens in a lot of cases because of the nature of the husband-wife relationship, there are no witnesses. A separate point on that, if there are no witnesses, and it's the issue of talaq al-mughallada, which is the severe irrevocable divorce, then the Islamic ruling on that is that it will be al-marratu kal-ka'bi, which is that the wife's word will be taken in that regard. So if, for example, there is a disagreement in respect of talaq, and the husband is saying, I only pronounce one talaq, but the wife is saying he pronounced 3 talaqs, then the wife's word will be taken on that point. But that's as an aside. Going back to talaq raji, so it is revocable. If the couple wish to reconcile, they can do so. What happens when talaq is pronounced is immediately the wife enters into something called the iddah period, the waiting period. And that's usually 3 menstrual cycles or 4 lunar months. I usually advise 3 menstrual cycles. And as soon as the talaq is pronounced, that waiting period begins. Now, there are a number of different wisdoms for that. First of all, it's to ensure that the husband, after giving talaq, is not going to father any of the children with the wife. So the 3 menstrual cycles puts that beyond doubt. Secondly, it's also a cooling off period. And it gives the parties time to reflect and think and see if reconciliation is on the cards. And if the parties do reconcile within the iddah period, and talaq raji or the form of words of talaq raji have been pronounced, then they are reconciled. It will be classed as one talaq having fallen, but the parties will reconcile and they will not need to perform any separate ceremony at all. If they reconcile after the expiration of the iddah, then they do need to perform a new nikah ceremony, a new Islamic marriage ceremony, and then that talaq raji will automatically turn into a talaq ba'i. So what is a talaq ba'i? To utter words which are kinaya, which are unclear as opposed to sarih. For example, to say, with an unclear intention about talaq, then that will be talaq ba'i. Or to say, I give you talaq ba'i. And again, I've rarely come across lay clients who know the existence of talaq raji ba'i mughallada, and that usually doesn't happen. Another way that there can be a talaq ba'i is when a talaq raji, the expiration period of the talaq raji has expired, the waiting period, and then the talaq raji after the 3 menstrual cycles turns into a talaq ba'i. And then if the parties want to reconcile after that, they can again perform the Islamic nikah ceremony. Also, a khula or a fasq or tafriq. So any dissolution done by a Sharia council or by Muslim court in Muslim country, or by way of khula, then that type of separation is classed as a talaq ba'i. And again, it's important, and I'll later talk about how that can sometimes be useful to know in proceedings for children, for example. After the talaq ba'i has been pronounced, the marriage comes to an immediate end. And again, as I said, if the parties want to reconcile, they can do so, but they need to perform the Islamic nikah ceremony again. So the third type of divorce, talaq al-mughallada, the irrevocable divorce, that is the method of divorce from which there is no comeback, no method of reconciliation. And this is pronounced by the husband saying, I give you 3 talaqs, or talaq, talaq, talaq. And unfortunately, this is the type of divorce that we have to deal with a lot, because it is a classic example of something within Sharia law which has entered mainstream consciousness within Muslims, so much so that it is regarded as the only type of divorce, and it is incorrect. It is actually haram, which means forbidden. It is actually forbidden to give talaq mughallada, and the husband will be sinful from a theological and divine perspective but it is still effective, unfortunately. As my old mentor used to say, somewhat crudely, but it's always stuck with me. Why fire 3 bullets when you can get the job done in 1? And that is why it's important that there is education about this, and people know and seek proper advice and go to scholars who know what they're talking about. And so if you are ever in a situation where a client is discussing with you about divorce, and Islamic divorce is being considered and discussed, and they haven't pronounced talaq, or talaq hasn't been pronounced by the husband if you're for the wife, then it's good to guide them to good independent advice, good scholarly advice as well, because the type of divorce is extremely important. There is an issue which is very, very, again, mainstream within the Muslim community. And again, there is a difference of opinion on whether 3 talaqs pronounced in 1 sitting counts as 1 talaq or 3 talaqs. And here there is a difference between the different madhahibs, the different schools of thought. And also because of qiyas and legal analogy between different scholars as well. This won't be the first time I say this today, but on this issue, you'll find fatwas. Fatwas are legal rulings given by Islamic scholars who are trained at jurist level. So you'll find fatwas on this issue both ways, and that 3 is 1 and 3 is 3, and on that regard. So it's important in that situation to find out which school of thought your client follows, because that is important. Again, one thing I should have mentioned about the schools of thought is their purpose is to maintain consistency of action for Muslims. So a Muslim can choose whichever school of thought he or she wishes to follow, but as long as they follow that school of thought consistently, because the ultimate objective is divine pleasure and to please God, and to please God in the way that the Prophet did it, in the manner and the mode of the Prophet Muhammad, peace be upon him. And so to follow one school of thought consistently is the acceptable and the preferred method. So it's important to ask what school of thought your client follows, if that's the case, because that may have a bearing on the situation where, if they are in a situation where triple talaq has been pronounced in 1 sitting, then it could have a bearing on that. Next slide, please, Helen. Thank you. So, of all these methods of talaq, is there a preferred way? Is there an acceptable or a Quranic way? And yes, there is. Talaq-e-ahsan is the method which is indicated and described in verses of the Quran. Here, the husband divorces the wife using sarih words whilst she's in her non-menstrual cycle, and in a period in which the parties have not had sexual intercourse. This leaves room for them to reconcile if they want, and if not, they'll be separated by way of talaq-e-ba'in after the expiration of the iddah period. And it's a point which I'll address later on as well. But again, the issue of what should happen to the couple who are living together in a matrimonial home, for example, or in a house, when talaq has been pronounced, is a very live issue. It's a very important one. The Islamic injunctions and the texts say that even though talaq has been pronounced and the parties are no longer classed as husband and wife, to aid reconciliation, and I say subject to safeguarding here and subject to safety needs, the wife is allowed to remain and should remain in the matrimonial home to assist reconciliation. Now, reconciliation between husband and wife, reconciliation between estranged parties generally, is actually a very, very big principle in Islam. The Quran has specific verses to state that if 2 parties have fallen out, you should get a 3rd party to try to intervene and bring the 2 parties together. But again, as a family lawyer and as somebody who in practice, this is all subject to safety and welfare. If by bringing 2 people together, you are putting somebody's life at risk, or there is a risk of domestic abuse or domestic violence, then Islam does not advocate that at all. And again, this is, it's not stated in any text anywhere that you'll find, maybe in the modern books written by modern scholars, but this is an example of qiyas, a legal analogy. Okay, do you want to go on to the next slide, please, Helen? Thank you. So tafweed al-talaq, the power of delegation. This is where the husband gives his right of unilateral talaq to the wife or a 3rd party. And there are different ways that this can be done. It can be either given to a 3rd party to pronounce divorce on behalf of the wife after an event has happened and there need to be witnesses, or it can be without witnesses, or it can also be a simple right of unilateral divorce given to the wife without need to consult any third party or any of the witnesses. It can be time limited. The parties may specify conditions, and indeed I have come across them most when there is an issue in respect of reconciliation and the husband is being given one more chance, so as to say. And one of the conditions is that he transfers his, or gives his right of divorce to the wife. He maintains it himself as well, but then the wife can divorce herself should he go down the same path of whatever caused the breakup in the first place. Those astute amongst you will have noticed in any marriage certificates that you've read from Pakistan, obviously the English translated ones, that according to the Muslim Family Ordinance 1961, there is provision. And there is on the marriage certificate, there is a space where it clearly highlights, does the wife have the power to divorce herself or not? I can't recall ever seeing that box or that space ticked, but it is there. So it's an example of civil law of a country taking the principles of Sharia and using that in the civil law, in their civil law. Again, through experience and through practice, I would say that it is always preferable when things like this are written down. Unfortunately, the issues that we have to deal with when in respect to these cases is the diametric opposite. Things are not written down, things are done informally. There are informal conversations with scholars, informal conversations with family members. And then afterwards, it's very difficult to ascertain the truth of the situation because nobody's willing to put what they've said to somebody over the phone in writing. I've included there at the bottom just an example of one of the texts that is classic, a classic Islamic text, and one which is well renowned, which is called The Guidance by Sheikh Al-Mawhinani. You can read the full name yourselves there. But it's to give you an example of how these things are recorded in the Islamic texts. It's not the FPR 2010. It's not written down in the same way. And it is the case that you have certain scenarios that if this happens, this will happen. If this happens, this will happen. So here's an example of the importance of intention. And intention forms a very big part. And in this quote, the Sheikh gives an example of when the husband may have given his tafweed al-talaq to divorce herself once, and she does it 3 times. Then it can be classed as 3 times if the husband had intended this. But again, how is that intention recorded? Is there any evidence of that intention? Those are questions which are scarcely answered in practice, unfortunately. Next slide, please. So why do we need a talaq? Why is it not the case that if there is a legal marriage and they go through the courts of this country and there is a decree absolute, does that not constitute talaq? It's a good question. It occurs time and again. I'm actually currently dealing with a case where this is one of the issues involved. What I would say is this: that unlike our civil justice system, there's no unified approach, no generally agreed authoritative position. People do go forum shopping for fatwas, just as people may go forum shopping for different jurisdictions when it comes to issuing proceedings, for example. And I've included 2 links there for you guys to click on and read. And they are 2 different opinions on the same issue. And one link says that it does constitute talaq, a decree absolute does constitute talaq, and one link says it doesn't constitute talaq. Now, the websites are very reputable. The institution Darul Ifta is very reputable in the UK. And actually, the second link is the scholar who gives the opinion in the second link is actually from the same institution. And the main point it centers around is the issue of something called wakala, which is to give agency or making somebody else your representative. And for the people who argue that a decree absolute does constitute talaq, whether it's the wife who is petitioning or whether it's the husband petitioning, that the husband has transferred his power of talaq to the judge. That's the main point that they make, that if a wife petitions and the husband replies in the acknowledgement of service by saying that he doesn't intend to defend the divorce, it is as if he has transferred his power of divorce to the judge. Or when the husband petitions himself, he's doing the same thing. I've included a quote here from a paper entitled UK Divorce Process and its Compliability with Sharia. Mufti Amjad Mohammed is somebody I've worked with in the past. And this paper was quite helpful. It's a good it's a good comparative analysis, but more so for scholars who don't understand the English civil legal system or the family laws in this country. But I've picked out the relevant quote here, which is the question asked is, do you intend to defend this case? This has been understood that the husband is making the judge wakil, which means the husband is making the judge his representative, in order to issue a divorce to his wife when he responds with no, or words to that effect, or words saying that I don't agree with the allegation, but I don't intend to divorce. However, that is not the case, as the act of wakala, the rules of wakala, requires an explicit statement of offer from the husband and a similar statement of acceptance from the judge. Admittedly, this can also be by action. However, in both cases, the intention must exist in both the husband, who is the muwakkil, and the judge, who is the wakil. As we know, this does not happen from the judge and cannot be accepted to occur by the above answer to the question. So we know the process, and based on that, it's clear. His opinion is very clear that the judge does not obtain the power of wakil from the husband. Therefore, when he pronounces the decree absolute, it is not a talaq, because there is a fundamental difference here. In the English civil family justice system, neither the husband nor the wife have the power to dissolve the marriage. It rests solely in the hands of the judge, whereas within the Sharia, within Islamic family law, it rests with the husband and can rest with the wife as well. It's also it's also important to consider factors such as the intention of the husband. If, for example, you could technically argue that if the husband recorded in, say, correspondence through representatives that it was his intention to give his power of talaq to the judge, does that constitute decree absolute? Well, again, there's not so much clarity here, because whilst he may offer it to the judge, there is no provision within the divorce process in this country for the judge to say, I accept your thing. So on that basis, and also through my experience as somebody who's dealt with so many of these cases, and how much more accepted a separate certificate which details the dissolution of the Islamic marriage is within the Muslim community, I would therefore err on the side of saying, as well as getting the decree absolute, you need a separate a dissolution of marriage to provide evidence of the dissolution of the Islamic marriage, whether that's a talaq granted by the husband, which is recorded appropriately, or whether it's a fasq or tafriq obtained through a Sharia council upon which there'll be a divorce certificate. Okay, next slide. Okay, so we're just coming up to 5 o'clock, and we've got, I'd say, about 15 minutes. So I'm going to quickly whiz through this. Meher and jahaz. Meher is important, and it's something which, again, requires more time than unfortunately we're going to be able to give today. But it is, generally speaking, it's the gift that the husband gives to the wife upon nikah. It is her Islamic right. She can do whatever she wants with it, and the husband has no say, has no claim over it. Technically speaking, the wife can demand a specific sum. She can demand whatever amount she wants. In practice, we always find out, though, that it's best to agree these things, and if there is sensible discussion around the topic before the marriage, then it can avoid situations where an exorbitant or high amount of meher is demanded by the wife from the husband, which maybe the husband cannot afford, and which may scupper relations even before the marriage is started. It can be a monetary value, or it could be an item of value. So there is a minimum payment of 10 mithqal of silver and I'll talk more about values later on in the next few bullet points. So yes, there is a minimum value, and technically speaking, as I said, there's no top end value. But this then raises problems within cultural aspects. For example, there are some demographics of Muslims from the South Asian continent which, from an Islamic perspective, request an amount of meher which is un-Islamic, has no basis in Islam, and is very high. Now, because this has become the accepted practice in that culture now, it is difficult to get away from those discussions if you're from that culture, if you're a woman in that culture, if you're a husband from that culture, if you're about to get married and your parents are having meetings before the actual nikah and talking about these things. So that's where there is a lot of confusion, and it can cause problems afterwards as well. The meher can be paid immediately, or it can be deferred to a later date as well, which is called mu'ajjal, or it can be deferred as a security in the event of death of divorce or the death of the husband. Now, in this day and age, and again, this is another good example of how something within the Sharia, which is not so, it's actually a weak hadith, but has become ingrained in the practices of Muslims worldwide, I'd say, but especially within Muslims from the South Asian continent, India, Pakistan, Bangladesh, and by extension, the Muslims who are from those countries in the UK as well. And that is the amount of meher, which we call meher-e-Fatimi. And the meher-e-Fatimi is the amount of meher that was paid to the Prophet Muhammad's daughter by Ali when he married her. And the incident is that he sold some of his assets, and he gave her some silver that he brought as a result of selling those assets. And translated to the rate of silver of the day, I think when I prepared this presentation last week, the rate of silver was coming up to £918. Now, the story of the meher of Fatima radiallahu anha, peace be upon her, is a great example of a weak hadith, but it is now so prevalent upon the practices of the Muslims. And you may even see that recorded in an Islamic marriage certificate. So that's what it refers to. Now, the stronger hadith is actually what Prophet Muhammad paid when he got married to his wife, which was, the actual amount is not too different. It's actually, when I checked it last week, it was £945. But again, it's a much more stronger hadith, therefore closer to the practice of the Prophet Muhammad, and therefore, as far as Muslims are concerned, more virtuous for Muslims to follow in those footsteps. I've put a link there for the website of a organization called Wifaqul Ulama. It's a good organization of scholars within the UK, and they have a separate page on there which updates the rate of silver. So you're free to check that as you would like. It is also acceptable in some circumstances for the wife and her family to stipulate a higher amount of the meher when there are some issues relating to the husband, whether it's neglect, abandonment, anything else which they know of beforehand. But again, subject to agreement, that can be agreed. And now all of this, and as I'll discuss later, it needs to be put down in writing, and when it isn't, that's when the problems arise. Now the jahaz, the next slide please, Helen, is different to the meher. Jahaz are the gifts that are given to the wife by either the husband or the husband's family, and these are more cultural in aspect and not from a strictly Islamic basis. And it's important to distinguish between the meher and the jahaz. Now, this could include household items, furniture, gold and jewelry, other gifts and equipments. And in some cultures, it's actually the expectation on the wife's family to provide these things to the husband. That's not the religious Islamic position at all. For the wife to provide a gift to the husband upon nikah, that's not dowry. That's not an Islamic position. It's for the husband. It's the opposite way around in respect of dowry. And if the husband wants to give something as well as a gift, he can do so. But there's no expectation upon the wife to give something to the husband. Now, whether that gift is conditional or unconditional, that's where we as lawyers are sometimes brought in, isn't it? Does the ownership pass to the wife, or does it stay vested in the husband and or his family? Well, in some cultures, it is an unspoken agreement, and unsaid, that the gold and jewelry separate to meher, which is not classed as meher, will be the wife's. But there's also a different position in some cultures that actually it is the wife's as long as the wife stays in the marriage with the husband. And if there is separation, then that golden jewelry comes back to the husband or his family. Again, depending upon the factual matrix of the particular case, that will depend on how that is perceived. But that's why it's important to record in the appropriate documentation what the gift is and upon what basis it's given. And I've set out some case law here. Most of you will be familiar with the 3 cases that I've set out. Shanaz and Rizwan and Uddin and Chaudhry are 2 examples of cases where there was a breach of contract claim based on the actual nikah ceremony, or the nikah contract, as it were, because the contract of nikah can be perceived as a contract entered into, as in the case of Shanaz and Rizwan, contemplation and consideration of marriage. And especially in Uddin versus Chaudhry, a good decision was made because the judge heard expert evidence and found that gifts given by the husband's family were absolute and non-returnable, so unconditional gifts, and not to be deducted from the dowry, which also still had to be paid by the husband to the wife. A&T was a claim in the financial remedy proceedings where the court looked to the practices of the Iranian court as to what it would do in the distribution of 100 gold coins that were promised to the wife by the husband upon marriage, which never materialized. So important points here to note are that it needs to be recorded in writing if it can. We'll talk about prenuptial agreements later on, but that would be the ideal place, in my opinion, for things like that to be recorded if these issues are live within the client that you're advising. Okay, next slide, Helen. Thank you. This slide is just to give you a bit of a brief background and just to show that within civil jurisprudence, within the family laws of this country, we have a good legislative framework and framework set out by case law. It is structured, it is there. There is provision for parties upon separation for financial provision, whether it's through the Matrimonial Causes Act for married couples, or whether it's through Talata for cohabitees. And the cases of White, Miller, McFarlane, Murphy, they are seminal cases. Miller and McFarlane especially highlighting the provisions and really doubling down on needs, compensation and sharing. But most importantly, the requirement of fairness on both parties, and both parties are able to have this. Next slide, please, Helen. Contrast that with the position on Islamic jurisprudence as it is in the text. And I'm not talking about anything in relation to qiyas here, which is legal analogy and what the position is now. And that's going to be on the next slide. But generally speaking, here are the main points. During the course of the marriage, the husband is responsible for the maintenance of the wife and the children, irrespective of the wife's income. If the wife is working and she has income, she is entitled to keep her income and entitled to be totally dependent upon the husband. After separation, the husband is responsible for the wife's expenses, but only until the end of the iddah, at the expiration. So only for the 3 menstrual cycles after talaq has been pronounced. And then only he is responsible for the expenses relating to children, but not any unrelated expenses of the wife. So that, at first glance, it seems unfair. And again, we have to remember that these principles haven't changed for a long time, and where there is provision or where there is agreement, and there is agreement within scholars who deal with these cases, that we can differ from this, and there is flexibility on this issue, is because of the analysis of what is happening in the 21st century, in 2021 in Britain. I'll quickly mention muta, which is something most people may not have come across. And I've never seen this in practice, but muta is the presentation of a gift to the wife by the husband upon divorce. So this is to minimize the acrimony upon divorce. The husband presents the wife with a gift according to his means, to maybe smooth over any cracks. But again, it's something which is there. I've never come across that in practice. It's maybe more prevalent within the Arabic countries and communities, but I've certainly never encountered this in practice. Now, at the bottom of the slide, I've put just one provision of the UAE Federal Law number 28, Article 62. This is one of the family laws of which is forms part of the civil code in Dubai. And just to show the different position that is taken by Islamic countries or Muslim countries when they derive their civil codes of law, which is based on Sharia, which is based on their interpretation of Sharia. And here it clearly says a major woman, and by a major woman that means a woman above the age of puberty, shall be free to dispose of her property. The husband may not dispose of her property without her consent. Each of them shall have independent financial assets. If one of them shares the other in developing his or her property, and that's the wording of the provision, or building a residence, etc., he or she may claim his or her share from the other upon divorce or death. So again, a clear indication that contribution is considered. What we class as contribution as one of the Section 25 factors, that is considered, and that the husband doesn't have any right to dispose of the woman's, his wife's property without her consent, and all of her assets are independent financially as well. Now, to the uninitiated and most lay people, this may seem to be discrepant from what the principles that I've mentioned at the top of the slide and other Islamic principles. But this is where I find a bit of controversy and a bit of difference of opinion with scholars. Next slide, please. And it's this question: is civil financial provision against Islamic principles? Is it against the Sharia? You've got the classical texts, you've got the classic, academia versus practitioners debate that you have in every field, and also the stance taken by scholars in this country, which have been very strongly influenced by culture and cultural factors. Now, when it comes to and also their misconception about civil family laws, a lot of scholars I speak to, they, as a very flippant comment, they always say that, well, doesn't the woman just get 50-50 anyway? And a voice inside of me then states, well, you clearly haven't read Section 25 or considered any other Section 25 factors. So there is a lot of misconception about the family laws of this country within the Muslim community, within Muslim scholars. And I've generally found that there is a difference between scholars who are in the ivory towers and jurists and scholars who have read the same books as the guys in the ivory towers, but are on the ground. Either they may have dealings with people with these problems on a day-to-day basis. They may be scholars who sit on the panel of the Sharia Council. And just to give an example of that, I sat on a Sharia Council for a while as their pro bono independent legal advisor for a long time. And one of the scholars who can be accurately classed as one of the biggest influences in my life, Sheikh Yaqub Qasmi, could be viewed as a very traditional classic scholar, born and bred in India, studied in India, brought up in India, and then moved to the UK in the 60s and 70s. And then and in the 90s, he set up a Sharia Council. And due to his experience on the ground in seeing the situation and the plight of Muslim women and the provisions afforded and the solutions afforded to separating and divorcing couples by the law of this country, he, as a very well-regarded and perceived to be quite a traditional scholar, he was very clear to everybody who came to the Sharia Council and in his advice to the scholars, in that if the Sharia for Muslims in this country does not provide the financial protection that women need and children need, it does not provide the justice that Islam is about. Therefore, to attain that justice, to go to the courts is not something that is wrong or frowned upon in the Sharia. And that's a classic example of qiyas, where through legal analogy, different positions have been taken. And again, like I said before, you will find fatwas either way. But there is no position in Islam for a child to be left unhoused or for a child and a mother to be left unhoused. And when subsection 1 of section 25, first of all, of the MCA 1973, places an obligation upon the court to have regard to the needs of any minor child, then for me, that's a classic example of the interplay between civil and Islamic family law, where there is similarity and not difference. And it's there to protect vulnerable parties. So my personal opinion is that no, it isn't against Sharia. Of course, I'm not a classically trained Islamic scholar, and you will find difference of opinion both ways on this. Next slide, please. Very quickly, children arrangements. I put this slide in there just to give people a bit of insight as to what Islam actually says. Now, most people are under the misconception that once a child reaches the age of puberty, Islamically speaking, the child must go from the mother to the father. That isn't the case. As you can see from this slide, 5 different female alternatives are considered before it's considered that a child goes to the father. And again, it's not the age of puberty, it's something called the age of discernment. The age of discernment is when a child is able to clean itself, go to the toilet and eat and fend for itself in that sort of way. But again, that's subject to the discussion of safety and welfare. What is in the best interest of the child as per the Children Act 1989? That is very much a live conversation within Islamic principles as well. And if there is a case that upon a child attaining the age of discernment, considerations and discussions are being had about the transfer of the child from the mother to the father, if that is against the welfare needs of the child insofar as safety or risk is concerned, then Islam will be against that position. But again, that is why in my advice to scholars and my advice to Sharia councils, and indeed something that they have taken up, is that if there is any dispute relating to contact, take it to the courts, take it to mediation, because the main question here, not only from a civil perspective, but also from an Islamic perspective to consider, is the welfare needs of the child. And that is the main thing to consider. Okay, it's 5:15. It's gone relatively quickly. I think I've got one more slide, and then we can move on to questions. Okay, thank you for that, Helen. So there are a few practice points, hopefully I've highlighted throughout the webinar, but I just wanted to focus on a few which keep on recurring time and again. Now, one of them is the impact on children proceedings, and more specifically, as I've had in a recent case, on a finding of fact hearing, when the court is considering PD 12J, and more specifically, controlling and coercive behaviour. The question could be asked, and it was asked in this particular case, that was the husband's refusal to give the talaq evidence of controlling and coercive behaviour? Is it a form of abuse? And in this case, it became a live issue for a while, and it was somewhat frustrating because I knew the answer, but I couldn't say it. And also, the evidence that was given really confused the judge. But hopefully, as you will now be fully conversant with after having attended this seminar, you will know that a khula is different to a fasq, where a khula, if a husband grants a talaq upon the request of the wife, then that is classed as a khula, as a consensual form of divorce. Whereas if the wife asks for a divorce and the husband refuses, and then she has to go to a Sharia council, and the Sharia council dissolves that marriage without any further input from the husband, aside from asking him his side of the story, then that is a fasq or a tafriq, and that can be classed as potentially a situation where the husband was controlling. He refused to give the Islamic divorce. And incidentally, I think one point I forgot to touch on, the Islamic injunction upon husbands is very clear when it comes to talaq. It's recorded in the Quran, it's a verse of the Quran, and the husbands are either told to retain wives in kindness or to let them go in kindness as well. And so and subject to exploring methods of reconciliation. If the wife is still insistent upon divorce, the husband shouldn't refuse to give talaq. Next is the impact on injunctions such as non-molestation or occupation order applications. And we briefly touched on that earlier on, that what is the Islamic position of the parties, or the status of the parties, once talaq has been pronounced? Now, strictly speaking, they are no longer husband and wife. But as Sharia does allow and would like, again, this is not an obligatory thing, it's just better practice to aid reconciliation. The wife is allowed to stay in the house to aid those conversations. But if there is abuse, if there is a risk of harm, then non-molestation order applications, the occupation order applications should be considered. And it could be something that is put in the application in the statement when addressing the issue of whether they can stay in the same roof, under the same roof or not. I would say that careful consideration needs to be given at the time. Careful instructions need to be taken. Lots of men and women, as you can probably guess from instructions given by clients, will seek to use different parts of Islam to their advantage, dependent upon what position they find themselves in. And I often find that husbands become extremely Islamic and practicing when divorce happens in order to convince people that no, actually this should be the case, when in fact, when it comes to getting up at 4 o'clock in the morning and doing the first obligatory prayer of the day in the summer, that's never happened in their lives. Sorry, that was my little dig. But the point is made very clearly that people do pick and choose. So it's important to know the facts. But it is not obligatory for a wife to stay under the same roof once the talaq has been pronounced. So if that argument is ever made, as I've ever encountered before, then that's the response to that. Prenuptial agreements and marriage contract. This is something which people do not use, and it's just in my opinion, there is so much scope for this to be used properly. After Radmacher and Granatino, we have the courts giving weight to prenuptial agreements and postnuptial agreements in this country, in our jurisdiction. And sometimes a well-drafted nikah certificate, or nikah nama, as people may say to you, may include terms such as tafweed al-talaq or the amount of meher. But in cases where I've advised clients, improperly drafted prenuptial agreements, which are enforceable by the court when it comes to issues relating to the finance and dissolution of the assets, something that can also be included to achieve and to show the court the overarching aim of fairness, which is the main point of a prenuptial agreement, is to explore the issues of tafweed, of the type and method of talaq to be given if the marriage doesn't work out, the issue of meher and jahaz, and, for example, other issues such as the location of the civil ceremony, indeed, when to have the civil ceremony. Some of you may know that I'm deputy director of a campaign called Registrar Marriage, which is trying to change the law so that marriages of all faith are automatically recognised by the Marriage Act 1949, which unfortunately isn't the case right now. So that's very, very important. And if sensible conversations can be had, then sensible points can be properly drafted by lawyers with the input of scholars and jurists. Absolutely, I've done that in the past, which from a Sharia point of view is compliant, which may not be enforceable by an English court, granted, but it does show the court the nature and extent of the discussions that the parties had or were privy to before entering into the prenup. And finally, very quickly, just a quick point on the documents to check. Please check your Islamic documents properly. If they're in another language, of course, get them translated. There may be a foreign marriage which is classed as or is accepted as a valid marriage for the purposes of English law by virtue of the Foreign Marriages Act 1892 or 1947. Generally speaking, if a marriage or divorce is conducted anywhere in the world, according to that jurisdiction, then by way of private international law, our jurisdiction here will accept that. A question I always ask clients is, was your marriage in the other jurisdiction used as the basis of your spouse coming into the country, and that's usually a good indicator of the status of that marriage. One bugbear of mine is the evidence of dissolution of the Islamic marriage. You'll have that if there has been an application made to a Sharia council. If there's been a decision made by them, then there will be what we call a certificate of dissolution of marriage. Sharia councils are a law unto themselves, unfortunately. They need to exist. I'm an advocate of that fact, but unfortunately they don't do themselves justice, and they don't have the best practices, unfortunately. But they do need to exist for Muslim women who are stuck in Islamic marriages where their husbands refuse to give divorce, and they are the mechanism. And going back to the issue of meher and jahaz, recording the intention of gifts. If it's not strictly meher, then highlight it, have an inventory, have a list of what it is, how much it cost, what the intention behind that gift is. Again, all of these things can be contained and drafted and put into a prenup or a Muslim marriage contract. I prefer a prenup simply because of the level of enforceability before an English court. But if it's in any other method, as long as it's written down, then it's better than nothing. And finally, before we go into the questions, one recent Islamic divorce case which I've advised on, and again, it's a bit of a technicality, but again shows some of the pitfalls of using a Sharia council, but also when clients become scholars themselves, which is that I had a case where we applied for a fasq or a tafriq in a dissolution of Islamic marriage. That was duly granted. However, based on an incorrect interpretation of Islamic law by a client, there was a contest of the dissolution granted by the Sharia Council, and the argument was that the client did not want a fasq or a tafriq. Sorry, the client did not want a khula, but the client wanted a fasq or a tafriq. And the question that asked was, can the Sharia Council grant a khula even when when the wife specifically petitions or makes an application for a fasq or a tafriq? It's an open question. There hasn't been a definitive ruling, but the short answer I would say to that question, and just to give a bit of brief insight as to how cases develop and mutate over the course of an application, is that what once started off as an application for a fasq or a dissolution or a nullification, if the husband then changes his mind, if he first refused to give divorce, but then he changes his mind to give the divorce, and in this particular case, there was actually a waiving of the meher. The husband actually said, well, fine, I'll change my mind. I'll actually give you the divorce, and I don't want the X amount of meher that I was initially asking to be returned. And on that basis, the Sharia Council then accepted that changing of position and granted a khula. Of course, the effect of that was still the same as a fasq. It's a talaq ba'in. It's a dissolution of the Islamic marriage. It was exactly what the applicant wanted. But it's important that, as it was in this case, that the clients have the correct access and correct understanding of the laws of the different types of separation. And aside from providing an interesting anecdote to you all, it also provides you with an example of sometimes when, because there is no unification and no authoritative source for all of this, you may find some pushback from your own clients as well. Okay, thank you very much for listening. It's been a dream come true in that I've been able to talk for an hour without anybody interrupting, and as everybody knows, lawyers love the sound of their own voice, especially myself, so thank you very much. Helen, I think I'll pass it on to you now.
Great, so we've had a question from Michelle, which, and excuse my pronunciation, if the parties enter into a civil marriage in a Muslim country and wish to divorce in the UK, do they still need a talaq?
Very good question. If it's a marriage conducted in another jurisdiction, but the divorce is conducted here, and and the full divorce process took place in the UK, i.e. it's not what the case law classes as a transnational divorce, then it will be a dissolution of the legal marriage. However, it will, and again, I go back to my slide about whether decree absolute constitutes talaq. I would say that doesn't constitute the talaq, because the decree absolute dissolves the legal aspect of the marriage, and not the Islamic aspect of the marriage.
Thank you. Does anyone else have any questions? Does anyone want to come off mute to ask anything? Just give it a second. If not, what we will do is we will share around the slides again, just for anyone who didn't see them before, so you can all have those. We'll also share with you Sadiq's contact details if you'd like to contact Sadiq about anything privately away from the main group, and we will share a recording with you just in case you want to watch back and make any more notes. Fantastic. No, I don't think there's any more questions actually, so thank you very much, everyone, and thank you, Sadiq.
Thank you.
Well, thank you for attending, everybody. I'm really grateful, and please feel free to email me directly or call me if you have any questions relating to particular practice points. I'm more than happy to assist.
Thank you, everyone. Goodbye.
Thank you. Bye.
Bye.